I just thought I'd begin by welcoming you all on behalf of our institute, IBIL, expressing extreme gratitude to our distinguished judicial visitor, Richard Arnold, for chairing it, and for our speakers who've all agreed to come. And then I'll tell you a story. Michael Feisch went to see his pupil master for the first time, Russell Clark, who had a distinguished monocle. And in Russell Clark's room, there were lots and lots of pairs of things. And you could see one was similar to the other. And he said, you know, I do a lot of designs. There's nothing to it. You pick one up, you pick the other up, and you say yes or no. I'm going to ask all these speakers later if that's really what happens. Richard, is it what you do? You better not answer.
Thank you, Robin. So, this evening we have for you an extremely distinguished panel. We have two authors, no less, of books on the law of European designs. Firstly, Professor David Musker from QMUL, and secondly, David Stone from Allen and Overy. And then we have someone who's extremely well known as an expert in the field of trademarks, having just written a wonderful commentary with Annette Keur on the subject, Martin Senftleben from the Vrije Universiteit in Amsterdam. And then finishing up last week, got Thorsten Gailing from Nestle UK. So they will be presenting in that order. They've all got PowerPoints, hence they're all sitting in the front row because it's the only way in this room that you can actually see the things. I'm going to go and join them, and I will invite David Musker to kick off.
Thank you, Robin. Thank you, Richard. So, assuming you can hear me, in this talk, I'm going to run through some of the things we looked at in the legal review of the design protection system, which I was involved on the edges of. It was an exercise we did for the Commission, I think, a year and a half ago, which you'll find on their website. And at some point, I'm reliably assured that it will go somewhere. Now, we have been blown a little bit off track by recent events in the UK. Whatever your views on those are, they have certainly taken our attention away from developments on the continent. And the Commission is going to be changing its membership, so there is a little bit of a hiatus at the moment. But the legal review and the responses to it, more importantly, are likely to come back onto the agenda in the mid-term. So this heads up may be of some use to you. Why is the Commission looking at reform of the design system? Well, the first issue is we've had the current system for 2 decades now, and there are a lot of people for whom if it ain't broke, break it, seems to be the motto. We are also in the process of recoiling from the reform of the trademark system, and no doubt there will be some lessons to learn from that. Following on from that, EU IPO needs to keep its trademark and design processes in step. It's very difficult to have 2 different sets of rules. It's difficult for us all to remember that the same rules mean different things in Munich and Alicante, and to have them mean 2 different things in Alicante too is just a little bit more than we ought to have to bear. And finally, there is, although it's moving at glacial speed, a move towards global harmonisation of design law. So just a reminder of the timescale. In 1986, a dreadful case called British Lane and Armstrong came out, and we all said the copyright and design system is broken. So in 1989, out came the Copyright Designs and Patents Act, and just as we were getting used to that and sitting through the round of seminars and reading the first wave of books, the Max Planck Institute announced in 1990 that the design system needed reform at European level. 1991, the Commission issued a green paper. setting out really all the basic ideas that have now made their way into law. And then over 1998 to 2001, the directive was implemented. We managed to get in 2 weeks after the deadline in 2001, and if any of you haven't read it, the judgment in Animal and Oakley at first instance is worth reading. If you haven't experienced the wit of Peter Prescott, you'll enjoy it. So it is now 20 years since 1998 when the directive was finalised, and we've had therefore 2 decades of substantive EU design law. In 2004, the Commission were meant to bring forward a proposal on spare parts because it was impossible to reach agreement across Europe on what to do about spare part protection under the design system. And this they duly did, and it was batted to and fro for 10 years and ultimately withdrawn in 2014 without prejudice to their right to bring it back. And this will be, for sure, one of the issues on the design reform agenda. In the meantime, while this was going on in 2008, Europe joined the Hague International System, and around 2013, the UK primarily was one of the movers in trying to get a design law harmonisation treaty rolling at WIPO. That too is stalled. I'm reassured by WIPO that this is a temporary thing, but they are professional optimists over there, so I'm more of a professional pessimist, I think. We shall see whether that gets anywhere in my lifetime. But more powerfully and more importantly have been the wave of bilateral trade agreements rolled out by the US and the EU, which since the US-Korea trade agreement have all required counterparts to join the Hague system. The US did that in 2014, Korea did that 2013, 2014, and as a result of these bilateral agreements, more and more countries are joining Hague, and as a result having to reform one aspect or another of their design law. And this rolling reform process is what has got a range of countries looking at their design laws in the round. So some of the substantive questions which we looked at in the legal reform were things like, what's the effect of the product, either the product in general or the product you mention in the design application? What's its effect on novelty, scope of protection, individual character? How do we deal with designs which are to be excluded for technical function, or bits of designs which are to be excluded for technical functionality? What are the tests to use? Spare parts, is there anything that can be done? When we say design, when we say the appearance of a product, what do we mean by appearance? Do we mean something has to appear, something has to be visible? What is the requirement, if any, for visibility? And in many ways, most important of all, but not something that's going to get fixed anytime soon, what do we do about copyright? Since we wrote, rather interestingly, several big cases hit the Court of Justice. Now, this may, of course, be coincidence. I would not wish to rule out the possibility that this is a coincidence. But it looks perhaps a little bit more like an attempt to clear the decks and see whether any of these issues can be resolved judicially before the legislative agenda is prepared. So the first one was effective product, and that got to the Court of Justice on appeal from EU IPO in a case called Easy Sanitary Solutions. Not going to look at that, probably you've read that already. The important thing about Easy Sanitary Solutions is that it says what we said in Green Lane and PMS plastics was right. So that's...
Anyone think so too?
Absolutely, absolutely. So that's a nice straightforward one. We can pat ourselves on the back for having shown them the way on that. What it doesn't do, in my view, is deal with how you treat the effective product when you've got to look at infringement and the product is different to the design registration. how do you deal with it in relation to individual character? How do you deal with it in relation to infringement? So still some questions there, which Easy Sanitary Solutions does not deal with. Technical function is on its way in a case called Dosa Ram and Ceram Tech. If you are familiar with this, these are strangely beautiful objects, which nonetheless are ceramic weld centering pins, and it's hard to believe that the intention was artistic, although the effect may well be. And we've had an Advocate General opinion on that. Don't hold your breath for the Court of Justice, but it should be sometime within the next 12 months. Thirdly, and this is one I propose to spend a little bit more time on, the spare part issue. Now, when we wrote, the status quo was that there were different regimes at the EU level and at the national level. So at national level, all that could be agreed was a compromise called Freeze Plus, whereby member states were allowed to keep their existing laws on protection of designs, or if they change them in the direction of liberalisation of the spare parts market. And some kept them and some changed them. The countries in red are those which have kept protection for spare parts, and at least two of the larger ones are countries that make quite a lot of cars. Some of the countries in blue, which have a repair clause, a repair defence, also make cars. Perhaps they don't last quite so long, but there they are. And then there are places like us that don't. But the map is half blue and half red is the important thing to note. So as exercises go in harmonisation, this one failed, actually, pretty drastically. It was a major failure of will of the EU in agreeing a solution. At EU level, the agreement was that since some countries did not want protection for spare parts, the EU level protection shouldn't force them to have it. So a liberalised solution granting the right to repair was included within the design regulation. So that's where we are at the moment. We've got a mess. Some countries have protection at full term for spare part designs. That's Germany and France. The Scandinavians have protection, but only 15 years worth, because they thought extending the term would be an illiberal measure. And then many other countries like ourselves have protection with a repair clause allowing repair. Just a reminder, our CDPA included a must-match defence. I know I'm not meant to call it that, Robin, but that's what we all still call it. Not a defence, an exclusion of protection for features of a component part which depend upon the appearance of the whole. And in the first draft of the community laws, there too was a must-match exclusion for features the appearance of which depended on the whole product. So features of spare parts, the appearance of which depended on the whole. So that's where the community law started off. Where it ended up was with Article 110, paragraph 1, protection shall not exist for a design which constitutes a spare part used within the meaning of Article 19 for the purpose of repair of that complex product so as to restore its original appearance. However, the recital, as we learn from a case of Mr. Justice Arnold, included additional words which were there in the beginning and which are there in the CDPA, words to the effect that the defence applies only to spare parts whose appearance depends on the appearance of the whole product. So there's a conflict between the scope of the article, which is a broad defence, if you like, and the scope of the recital, which, if you read it into the article, would considerably narrow that, and the things which would be excluded by reading in those words about dependency include things like alloy wheels, and we know this from Ford and Fiat Iveco from many years ago. What was in the Commission's proposal? Well, the Commission proposed that national laws would all contain the same kind of spare parts repair clause as is in the regulation, namely any component part can be used for the purpose of repair. And additionally, a clause protecting indications of origin so that the spare parts makers can't pretend that their parts come from the OEM. But it was vetoed by a number of countries, including, surprisingly enough, France and Germany, and so it died the death. Now, France and Romania, their competition authorities, have since had an epiphany and realised that perhaps protection of spare parts might indeed be anti-competitive and drive up the price of repairs, but their governments have done nothing about this. And so the Commission's proposal, as I say, has gone. Once it disappeared off the table, what seemed to happen pretty promptly was a series of test cases by the German automakers, Audi, BMW and Porsche, one of which reached the High Court here, others of which have been litigated in Germany, in Italy, in the Netherlands, in Spain, largely across Europe, to work out what the effect now of the clause we seem to be stuck with is. And the recent decision, the September judgment in Acacia in bankruptcy against Audi and Porsche, summarises the different decisions pro and anti, although for some reason it doesn't mention ours. And the Advocate General, in his opinion, comes to the conclusion that there was a deliberate act of will by the Council to adopt a broad repair clause. Interesting, I haven't seen an Advocate General opinion in our field, at least, that crawls through preparatory materials like that. And in fact, the Advocate General does admit that there's no bullseye when you do so. So it's not necessarily the kind of exercise that we would do here. The Advocate General says you can't get a definite answer by looking at these preparatory materials. But nonetheless, that's the Advocate General's opinion. The Court of Justice seemed to have agreed that this was a deliberate measure to take the broad view of Article 110 and ignore the effect of the recital. So that is what they did, and we now have a broad defence. This rather torpedoes, I think, the chances that the Court of Justice solution would be satisfactory to all the parties around the table. I suspect this means that the Commission are going to have to try again with some kind of compromise proposal. More interestingly, perhaps, at a practical level, or as interestingly, is what the court did. They give F on the one hand, and they take it away with the other. And what they have taken away is in relation to what third parties can do. So in a case called Ford and Wheel Trims, the Court of Justice said quite rightly that having this repair clause didn't give you a defence to trademark infringement if the spare parts contained a trademark, as Ford's did. The interesting issue when you get to the Acacia case, however, is that the Court of Justice in Acacia say the replacement must be identical to the part which was on the vehicle, or whatever it is, when it originally went on the market. And that seems to mean that if the original part had a trademark on it, you can't take the trademark off, because it wouldn't be identical then. Or put your own trademark on, because it wouldn't then be identical. The Advocate General recognised this issue and said that merely swapping your own trademark for the one that was on there shouldn't change matters, it should still be identical. Because if you didn't do that, the trademark protection would allow design holders to render the scope of Article 110 non-existent, which is true when you think about it. All you have to do is put a trademark on, and then the third party can't use the trademark and can't leave it off. But the Court of Justice didn't include the Advocate General's comments, and I think he's wrong, frankly, and especially if you think about something like the Jeep grille, which is the trademark. How can you take the trademark off in a case where the shape is the trademark? So that was the main point. The trademark issue by these two conflicting cases leaves third parties in a difficult situation. And then I won't dwell on this, but the other thing is the very heavy burden the court places on the spare part manufacturers. And although it says they are not necessarily bound liable in all circumstances, they are required to put contractual conditions on everybody downstream from them that the spare parts will only be used on to replace the same part on the original vehicle. So quite onerous conditions on the spare part makers. So with that, I'm out of time, and I will pass you back to Richard.
Thank you, Gailing. Just one small addition by way of explanation for those who have not read the Advocate General's opinion in the Dosa Ram case. He says the inclusion of recital 13, the key words, was, quote, a mistake. And that's the rationale. So you believe that or you don't believe it. But that's what the reasoning hangs on, is that the idea that the key words in recital 13 were a mistake. We now have David Stowe.
Ladies and gentlemen, good evening and happy Valentine's Day. Can you hear me if I put that there rather than hold it? Yes? Okay, good. I was asked to try and predict the shape of things to come, try and predict the trajectory of design law from here, and I was asked to try and do it focusing on two key things. One was the recent Supreme Court decision in Trunky, perhaps not so recent now as it once was, and also looking at some other aspects of the study that David Musker wrote, or part wrote, contributed to, and has already partially discussed. So that's what I was asked to do, and so that's what I will do. One of the questions I was asked to ask, and I will tread very carefully in trying to answer, is the Court of Appeal RCD unfriendly? Now, there are some statistics. The statistics are that the Court of Appeal of England and Wales has never found a registered community design to be valid and infringed. Shall I say that again? The Court of Appeal of England and Wales has never found a registered community design to be valid and infringed. Of the cases that you see there, I think Apple Samsung does stand out. Now, you would say, David, you would say that. And you're welcome to say it, David, you would say that. But I think that case is different than the other three because there were, I think, 56 from memory, pieces of what was described in the case as kindred prior art. The Apple design was not a significant departure from what there had been before. That is not like the other three cases. So in the other three cases, the P&G sprayer had won awards. Yes, there are awards for air freshener sprayers. Trunky was revolutionary. There was, as it was described in the Court of Appeal, clear blue water between the design in question and prior designs. They were all held to be valid, and in Samsung Apple that wasn't an issue, but none of them was held to be infringed. I think there are a number of reasons that we ought to be giving a broader scope of protection to community designs and the national registered equivalent. The first is because the legislature told us to do that. Now, follow me down this little path a little while. We know that the test for infringement is the flip side of the test for validity. There is an extra element in the test for validity. Not only does a design have to create a different overall impression on the informed user, but it also must be novel. To be novel, it can't be identical to an earlier design. But identity is given a Euro meaning, not its ordinary English meaning, which means the same as, but also not very different at all. So in essence, you have a novelty test that is not identity. It's a bit more than identity. From there, we then put another test on top of that, which is the overall impression test. So that has to go even further still, I would say. So this penumbra of protection, if I can call it this, the ambit of protection from English identity, real true identity, to include novelty identity, which is a bit broader, and same overall impression identity, takes us further still. So I would say that the legislature tells us that we should be giving a broader scope to registered designs. The Court of Justice also tells us that. It does it a little bit obliquely, and if it's not going to upset the camera person, I'm going to come down here to do this. The Court of Justice has told us that the informed user, so this person who assesses overall impression, is not the reasonable consumer from trademark law, reasonably circumspect consumer from trademark law, and is not the person skilled in the art from patent law, but someone who is between the two. And the reason they did that, in my view, is because the reasonably circumspect consumer might be, someone in a hurry, someone with imperfect recollection, all those tests we know from trademark law, will not notice many differences. So for them, many more designs will look similar, create the same overall impression. And that has the effect of meaning that very few designs are valid, but those that are valid are likely to be infringed. Over here with the expert, he or she will notice all sorts of differences. So for them, every design will be valid because they'll all be different, but very few will be infringed. So what the Court of Justice was telling us in putting the informed user somewhere between the two and saying we don't really like imperfect recollection for designs cases is somehow to try and find that balance of the right number of designs being valid and infringed. So not over there where we have the reasonably circumspect consumer, and not over here where we have the patent expert. Now I would perhaps bravely put a number of cases further towards this end. So where we have plentiful numbers of designs being held to be valid, but not being held to be infringed. Because perhaps we're putting the informed user too far towards the person skilled in the art in patent cases and not close enough to the reasonably circumspect consumer in trademark cases. The third reason I'd give for why we ought to give a broader scope of protection to designs is because that's what's going on in the rest of Europe. If you spend a little bit of time, and that may not be a good reason for doing things, I appreciate that, but if as a court system we want to be somewhere that people come to litigate these rights, then we have to provide the sort of service that people are after. Now, I'm not advocating the sort of overnight ex parte injunctions that the Düsseldorf court will grant in design cases and will grant in the tens of each year. I'm not advocating that at all. But I do think that the question, is the Court of Appeal RCD unfriendly, is a useful sort of question to ask, even if I'm not permitted to give you an answer. I think, too, there's a really good case at this point to be made for the IPEC, where I think we are seeing, as practitioners, designs upheld and designs found to be infringed. And that's, in my submission, a good thing. Some other learnings from... There we go. Some other learnings from trunking. I'm not going to say too much about the case itself, because I've written about that at length, and you're welcome, if you want those views, to have a look for them. But I think there's some fairly basic things we can take from it as practitioners. Obviously, file early before you publish a product. That's always a good suggestion. Many practitioners prefer not to rely on the 12-month grace period. Just get it in before you disclose the product at all anywhere in the world. File a cluster of rights, so try and protect in different sorts of ways. Colour photographs obviously disclose materials, will disclose colours, materials, texture. A line drawing won't disclose any of those things. The balance, of course, is that a line drawing is more likely to be invalid, but it will offer a broader scope of protection. The best thing I've come up with, and would really welcome other people's views on the point of whether or not a CAD rendering is a claim to absence of surface decoration, and just saying it helps you realise that it's probably not the case. But if that is the way the law is going, then one answer is to draw some surface decoration onto your design, but put it in dotted lines. So indicate that it's not claimed, but also remove any suggestion that the CAD drawing is a claim to absence of surface decoration. So there's surface decoration there, there's no absence of it, but it's not claimed. And I think that's probably the best I can come up with as a suggestion to get around that particular one. And those of you who've read the first instance decision in that case will know that the unregistered UK design rights were upheld for a number of aspects of the product. And it may well have been that if registered rights had been filed for some of those smaller innovative parts, the clasp, the way that strap attached to various bits and pieces, that those may well have survived and been held valid and infringed. So those are some brief thoughts on Trunky that I was asked to give. A few other issues that crop up in the study that David talked about. The Hague system, I'm a fan. I think it works. I think we've seen with the expansion, particularly to the United States, South Korea, and Japan, that it is possible to use it. It is possible to get registrations through without having to instruct local counsel. It's a good thing. I would like to see the EU make it mandatory for member states to join as part of this review process. We'll see. I'd like to see renewal fees at the EU IPO fall. There is going to be another study. The study recommends a further study on fees. The renewal fees increase as the design gets older, which just doesn't seem right. If you're thinking user pays, it doesn't cost any more for the EU IPO to press the button another 5 years, please, as the design gets older. And certainly David mentioned some of the international harmonisation efforts that are going on. Deeply, deeply important from the perspective of a practitioner, from the perspective of designers, because at the moment you may have to use different drawings wherever you go around the world. That adds to expense. It discourages SMEs, discourages individual designers from seeking global protection. And we all know with the internet that something that's published in one country will very shortly be pretty much everywhere else. There we go. It would also be lovely to see a harmonised approach to dotted lines. The EU IPO publishes guidance on what dotted lines mean. There are decisions from across the EU that hold they mean all sorts of other things. That just makes life difficult when you're trying to submit a design application because you don't get a chance to say, in this design, dotted lines mean this. There's no valid way of doing that at EU IPO level. There is at UK level, which might be something to consider. But unless drawing conventions are truly that, conventions that we all abide by, then it makes it very difficult to make that work. I'm very keen to see mandatory office procedures for invalidity of designs across the EU. My understanding is it's roughly half-half. Some countries, like the UK, provide invalidity proceedings through the office. Others, you have to go to court. And if you're trying to clear the decks to launch a product on an EU basis, having to file court proceedings is complex. For many companies, that requires a higher level of approval within the company, sometimes even board approval. So it slows things down, makes things more expensive. I'd also love to see declarations of non-infringement mandatory across the EU, and that's for trademarks and designs. Currently, both regulations say to the extent offered by the member states. So some countries do, some countries don't. We do, Germany doesn't, for example. And because of the way the cascade works that forces you to a particular country to commence your declaration of non-infringement, if it forces you to Germany, for example, you're seeking a declaration of non-infringement against a design owned by a German entity, you just don't have the option. You're forced to Germany. Germany doesn't offer them, so you can't get a declaration of non-infringement. So the answer is either to do that through the enforcement directive, which is also currently under review, or do it through the design review and hope that trademarks follow in due course. A few quick thoughts on some other things. Graphical user interface is obviously incredibly important in modern society, protectable in the EU, but not elsewhere. So there are still countries that won't allow you to protect a graphical user interface or require you to put it on a product. So you have to show a screen with the surround, with the GUI on it, with the result that the protection is limited to that as part of that particular product. Whereas graphical user interface is often used across various different sorts of products. So keep that in mind. 3D printing, the study also looks at 3D printing and doesn't conclude. It says that a further study is necessary. My sense of it, and there's a bit of a plug at the bottom of that slide for an INTA document that's available on the INTA website, that has done a very thorough review of the law in relation to 3D printing. My view is the law probably is sufficient at the moment to deal with the threat at the moment. Whilst it is still cheaper to buy a Barbie doll in a shop than it is to print one at home, then the threat is not as great as it might one day get. But there will be another study suggested by the study to deal with 3D printing. And I think this is also a very interesting area. Singapore has just reformed its design law, and as part of that has, wherever it mentions a design in the Act, also talks about or a virtual design, because they were keen to protect things that are projected. So, for example, a projected keyboard that you can type on. And for some other reason that I don't fully understand, dancing fountains. But certainly the experience. We read in the press all sorts of things about people not collecting assets anymore; they're now collecting experiences. So we need to be able to come up with ways to protect those experiences. Trademark law may work; passing off may well work, but design law has a role to play. That was it from me, and I think I'm back at the end to answer questions.
It is a very odd feature of the designs regulation that it gives the applicants the option of submitting a description of the design, but then says that if the description is submitted, it cannot be taken into account when assessing the scope of protection. My answer to Trunky is simply to reverse that and say that if a description is submitted, then it shall be taken into account when assessing the scope of protection. And that way, you can put in a statement and say what you're claiming, just as we used to do under our old law, which is a very rational way of doing it. So, Martin.
Well, thank you so much for the kind introduction, and thanks to the organizers. It's great to be here. And as you see from the title, I'm approaching the trademark context and asking the question if there is still hope within trademark law. I do so in 3 steps. So I will first give you an overview of the trademark tragedy. At least this is what we hear in practitioner circles very often. And then the question, is there any escape? And then finally, my personal assessment of the situation. I leave enough points for discussion, pretty sure. So the trademark tragedy, well, it's all started with the early decisions, which ever since have been confirmed. We had a further confirmation last year in the Knoppers case. It is more difficult to establish distinctive character with regard to shape. Of course, the Court of Justice always says, well, the assessment basically is the same, but then the court also says that consumers are not in the habit of making the necessary assumptions based on shape. So consumers do not learn anything. For years and years and years, they are still at the same stage of just not understanding that shape can be a source identifier. So as I said, this is still the starting point, and in August Stork, we heard the same thing last year. There's another point which we know from the Henkel decisions. There are exceptions conceivable, so there are shapes that are inherently distinctive, but for this to be achieved, you have to show that the shape significantly departs from the norm or customs of the sector. So if you now think, well, okay, that's good news. We just convinced those people that the shape is very, very special and departs significantly from the norms or customs in the sector, then you should have a look at the functionality doctrine in EU law, where we know from the Haug-Stocke case that, well, to establish aesthetic functionality, which is basically the substantial value shape question, there's a whole list of factors that impacts the analysis. So it's not just that a shape is particularly beautiful. No, it can be other factors as well. And I've highlighted one, and this is the dissimilarity from other shapes in the market. And so if you have followed what I have just said about distinctiveness, you see quite clearly the dilemma. To be distinctive, well, inherently distinctive, the shape must be special, but it should not be special to such an extent that it falls under aesthetic functionality rules established in Haug-Stocke. So, well, on the one hand, a significant departure from the norm in the sector is advisable. On the other hand, don't be too ambitious in that area, because ideally you would find some shape that falls just in between the two extremes. So, special enough to be distinctive, but not so special to be functional from an aesthetic perspective. Well, if this is the dilemma or the tragedy, then the question is, how can you survive? And there are some escape routes that have been tried and that are closed. We know this, and there are others which are still open. So I start with the closed roads. The functionality doctrine is applied quite broadly. So you cannot simply go to the office and the courts and say, well, you know, this is not a shape at all. This is just a 2D representation of something else. We know from the Yoshida P-design cases that this does not work. And anyway, after the amendment of EU trademark law, it doesn't matter whether it's a shape or some other characteristic of the product. So this is not an advisable strategy. You can try and add decorative features, but also there the assessment is quite critical, because the court says very clearly, well, these decorative features that you add must really play an important role when we look at the shape. So we will not just buy any decorative feature argument that you are advancing. You really have to show that it is an essential part of the design of the shape. Otherwise, we apply the functionality doctrine. And then schematic graphical representation does not help, because the court, and I think this is actually a quite logical development, the court no longer just looks schematically at the representation, but also when it is known what the actual use of the goods is, it will look at the actual version. So this is about the Rubik's Cube. And the court said, well, we know from practice that this is the Rubik's Cube and that it has these functional technical elements to it. And so we base our assessment of what we know from the real world and not the paper version that may not show any moving parts. And then finally, it does not help to try and tell a story that it's not a shape at all, or it has nothing to do with the shape at all, and it has nothing to do with product design, and say instead, well, it's just about an abstract color, or it's a position mark. This has been tried in the Louboutin cases, and at least if you can believe the two opinions of the Advocate General, then this argument would not fly either. But, well, this is, I mean, we have to wait for the judgment, of course, and actually I can't wait. I mean, I'm really looking forward to the judgment. Actually, it's also a nice story when you speak about this during a lecture or something. So, I mean, people immediately have strong feelings about the Louboutin shoes. So it's a wonderful thing. So actually, if you can believe the Advocate General, then these arguments would not have much success either. So if it looks like a shape, or if it is clearly attached to a shape, they will still focus on functionality for the time being. So now the question is, are there any survivors? Of course there are. If you remember the Lego mannequin case, I think a 2016 case, so there quite clearly it was said, no, this is not functional. And the reason for this is that you can't mix functionality grounds. In order for a shape to be found functional, you need 100% nature shape technical functionality or aesthetic functionality. This comes to the fore quite clearly in Haug-Stocke, has been confirmed in the KitKat case, and actually when you look at the results at the national level, in the Haug-Stocke case in the Netherlands, the Dutch Supreme Court ruled in November 2015, after the answers given by the Court of Justice, that in fact the case had to be done over because the focus had been so much on combining different grounds of functionality instead of focusing on just one. Perhaps this was one of the reasons why the parties settled afterwards. So if you ask me what was the final result, we don't really know, but we have this Supreme Court decision as a final step. So in the Lego mannequin case, for example, it was said that, well, it is not 100% technical. It has some functional elements to it because you must be able to combine it with general Lego bricks, but still the Lego mannequin is just a particular element that resembles the human body to some extent, and this does not make it functional from a technical perspective. There's of course also an escape route in the area of distinctive character. If you can't show or you don't want to dare showing a significant departure from the norm or customs in the sector, then you can try secondary meaning, acquiring distinctiveness through use, but I mean, you know this better than I do because you had all these wonderful KitKat cases here in the UK. This can be quite a difficult test. It follows quite clearly from case law of the Court of Justice that the focus really is on the shape as such and not anything else that you are showing together with the shape, any word mark or something. And then you must present proof that the shape alone identifies particular origin of goods. I also like the discussion in this decision here in the UK, where it has been confirmed that the question is whether the mark has acquired the ability to demonstrate exclusive origin. So it's not enough that consumers understand that it is a special shape or something, or that they have an idea of, well, this looks a bit like KitKat. You have to do more. You really have to show that there is a clear link between the shape and a specific commercial origin. Good news in the area of distinctiveness, I think, is what the Advocate General said in the Louboutin cases about the impact of distinctiveness and a high degree of distinctiveness on the functionality analysis. According to the Advocate General, this does not matter. So the attractiveness which a shape has because of acquired distinctive character, because of trademark recognition, would not impact the functionality assessment. I think this is a departure from the Haug-Stocke case. So we have to see how the court finally deals with this question. I read Haug-Stocke as saying, well, if there are advertising campaigns focusing on a particular shape, then this is a problem for the functionality analysis. So the Advocate General is much clearer in that respect. I think this is also the traditional Benelux position. When you look at the old Overy cases, it was also quite a clear focus, distinction between beauty of the shape as such and attractiveness which the shape has as a distinctive sign. So that's where we stand. Is it a nightmare or is it a dream scenario? Well, depends on who your clients are, I think. I try to give you an academic position on that, so bear with me just for another second. We have cyclic IP systems, and I understand as a cyclic IP system, a system that is based on a contribution of a creative person who takes something from the pre-existing material, public domain material, and creates something new or original on that basis. So, well, the author or the inventor or the designer is somebody who takes something from pre-existing knowledge, creates something new or original, and then we provide protection for a limited period in time. Trademark law is different because the focus is on transparency. As long as somebody makes genuine use of a sign, it can stay protected, can be protected in eternity. So we deal differently with the intellectual resources that we have. The system is static instead of being cyclic. And this means that we have quite clearly a conflict between the systems. So here's the conflict, so that's my arrow, and these are the static signs. And that brings me to my final conclusion. If we look at the whole issue from a societal perspective, it makes sense to be really, really careful in trademark law, because once you include all these creations under the umbrella of the trademark system, they may stay protected for a very long time. And so actually I think that the developments we see are quite logical from a bird's eye perspective of societal interests. And from that perspective, I also have a bit of difficulty with the punishment argument against the developments in trademark law. It's often said that EU trademark law punishes good design, because the better the design, the more beautiful the design, the more difficulty you have in saying that it is not functional from an aesthetic perspective, or making other arguments. So I understand the argument. Still, I think the punishment point is not really fair, because we offer protection in all these other systems. You can have industrial design protection, you can have copyright protection, so what else do you want? Of course, I'm arguing a bit on the basis of what you see on the continent in the Benelux tradition. Nobody registers industrial designs, and nobody cares so much about the dotted lines, because you get copyright protection all over the place. As you know from recent prejudicial questions asked about whether you can copyright the taste of cheese. So on that note, thank you very much.
Just for those of you who have perhaps forgotten this, a nice little illustration of the phenomenon that Martin was talking about, of the trap for the trademark applicants, is the Bang & Olufsen loudspeaker design case, where it was accepted by the General Court that the design of the loudspeaker departed from the norms of the sector and therefore was distinctive, but then in the second decision they said, therefore, you're caught by aesthetic functionality. Wonderful. So we now have Thorsten.
Thank you. I think we're broadly on time, so I will conclude. I will try and keep it that way. So I will conclude with a few thoughts by industry who are users of the various routes we've heard all about this evening. I've come up with a few challenges just as illustrations which obviously Nestle and other similar companies might encounter when trying to take advantage of those various routes that have been outlined. Challenge number one is the curse of choice. There's various routes available, of course. Within those routes, there's various subsets of routes available, of course, and within those, there, of course, is many decisions to be made. We've heard about registered designs, registered trademarks, copyright, of course. There's different filing routes, of course. There is decisions to be made on representation. Shall we use line drawing? Shall we use color photographs? Shall we use black and white, or whatever else we might be able to use? So there's a number of choices, of course. For some organizations, not Nestle, choice is a good thing. There might be an organization, they have a global head office, they look at all those choices, they come up with a guidance note for people, it gets cascaded down to all their national companies, and it's executed very well. For an organization such as Nestle, choice is often not a very good thing. Nestle in business speak is a matrix organization. In Nestle's own words, it's a decentralized and aligned organization. So dealing with this choice is a very difficult dilemma. Alignment takes time, and very often it's never reached, and no decision is reached. The second challenge industry faces is what I call the marketing expectation challenge, of course. So the instructions for marketing are on the slide. They're very clear, of course, and in a marketeer's mind, it's very simple to execute, of course. Where does that leave, obviously, practitioners, in-house legal teams, of which I'm a part as well? There are those routes available, of course. I think that the sort of challenge for in-house legal teams, of course, is how do we communicate with this person on the screen here and explain that even in cases where we have an IP right over a product shape, be it a registered design or even better, a registered trademarks, there will be limits to that IP right. Strangely, when it comes to product shapes, marketing's expectations are high. When it comes to more traditional trademarks, which say we have acquired through acquired distinctiveness, such as a word mark, marketing's expectations are often very low, which is surprising. So say one obtains a trademark for a descriptive word, such as gourmet, which is a big Nestle brand, through acquired distinctiveness. Someone uses that very thing for the exact same things we have it registered for. Marketing's expectations often are low, whereas for product shapes, marketing's expectations are high. So I suppose looking at the options we have, registered designs, we've heard about trunky, so that's the challenge number 3, the registered design challenge. We've already touched on trunky. I've just put a few images on screen, I suppose. So this is my first example, and we've heard about Vrije as well, which is my second example. I've put it down as a challenge because the question and I'm sure others will ask themselves is, if we obtain a registered design over something that merits registered design protection, marketing will like us, I'm sure. Along comes a copy as close as this one, or as in the trunky case, as close as the trunky copy. The case doesn't settle, we lose. Who would wish to speak to the marketing director or chief CEO in the company and explain that unfortunately it wasn't close enough? So in this example, I think the challenge I can see would quite categorically be, if that isn't close enough, what is close enough? Why do we bother with this? So if that is the challenge on registered designs, of course, the sort of one of the ways out of the dilemma is go down the trademark route. And of course, that has its own challenges, and I will touch on those towards the end of this. Before I come to the acquired distinctiveness challenge and the sort of real-life problems that poses for industry, I've put together a few little examples just of what I would consider iconic shapes, which most people will recognize. The first one is the Valentine's Day shape. Clearly most people recognize this. It's so iconic, it's been licensed to a jewellery company. They make a platinum version, which retails for just under £6,000. They make, of course, I mean... Not anybody enough for that. Well, there will be some, there's other versions, of course. There's a gold and silver version for those. I mean, of course, love comes in shades, of course. So if it's not big enough, then there's the more budget version, of course. The next one, Polo, launched in the 1940s, I think. Again, the shape coupled with the strapline, the mint with the hole, I'm sure everyone will recognize. It's consumers feel so emotional about it. There was a scare back in, I think it was in the 1990s, when April Fool's Day 1995, when the whole, and it was blamed on an EU regulation, which I actually don't believe exists. I tried to find it, and I don't think it exists, this piece. Clearly fake news even back then, I suppose. But another example. Again, many people will recognize these. There is a whole range of compatible capsules out there. I would query, do any of those look as good as those? I'm not sure they do. And I conclude, of course, with the Kit Kat shape, which of course we've already heard about. Again, all these shapes were launched decades ago. All these shapes will be recognized by people, I'm sure, no problem. So what is the acquired distinctiveness challenge from an industry point of view? That is the solution I put up for it. So what are the sort of challenges industry face when we talk about acquired distinctiveness? I suppose the mission statement is clear. We know what we have to put together to get over the hurdle. The challenges are often challenges one might not believe exist in large corporations. So the first challenge is the one of document retention. Nestle employs something around 350,000 people around the world, pretty much in all countries you can imagine. Who is responsible for keeping the sort of things we need to get over the acquired distinctiveness hurdle? To my mind, I've been there 10 years, it's not clear. Is it the legal function? Is it the marketing team? Often things are not there. Invoices clearly aren't kept that long. Sales figures aren't kept that long. Computer systems should be sophisticated. One might assume they're not. So of course, from an industry point of view, that poses a significant resource issue, of course. The second point, of course, surveys. You know, it's very popular. Most of the time, one gets persuaded, one persuades themselves or gets persuaded by external panel law firms. A survey is a good means of showing what consumers think, of course. I suppose at least in the industry in which Nestle operates and many other FMCG companies, the products are such that one might query, is there ever a need for a survey? Is it ever going to tell us anything that we do not know already, of course? So these are everyday consumer items, and I would argue that most of the surveys I've seen in terms of recognition or any other surveys, they essentially confirm what we know already. So what are sort of solutions for industry to get around these issues? Technology is one option, of course. One could envisage a world where a company such as Nestle utilizes all the marvelous systems that are out there, be it there's Facebook for Business, there is Microsoft has a whole raft of technology solutions, which in principle could be used to make our life easier if we ever need to submit evidence of acquired distinctiveness, of course. Are these systems available? Yes. Are they used? No. They're clearly not used to their sort of full potential. You know, I think there's a long road ahead to ever get to a point where we basically get our house in order. The final challenge from a practical level is, of course, that marketing, all this is a distraction for business people. So persuading marketing people to gather all this information is a big job. It's not their day job, of course. And as a result, what can happen, and I'm sure has happened on more than one occasion, the information is gathered in a rush. It's the marketeer's least problem. What they care about is next week's big product launch or campaign. And to give a Nestle example, what that has resulted in on one occasion, marketing have clear instructions to just provide something very basic, sales figures for the UK, which one would assume is a very simple instruction. And that is translated, and the marketeer said, into sales figures for the territory in which we operate, which is the United Kingdom and Republic of Ireland. So what comes back is a set of figures, which we are told is our figures for the United Kingdom. Of course, they're not, of course, and the figures are submitted to the IPO. We may get the trademark. At some point, we come to enforce it. In the enforcement action, of course, new evidence is filed. The mistake we made back during the prosecution becomes apparent, of course. It can be sorted out, but clearly any defendant would make a big deal of it and cause problems, of course. So I suppose other than bang your head against the wall and try and keep calm, I conclude with a few words, sort of judicial guidance, which come from the KitKat case, of which we've touched. The first one is some words of guidance. This is the High Court in KitKat, talking about the evidence we filed. The second piece is the Court of Appeal in KitKat, which is slightly less committed, but nonetheless, of course, the sort of things obviously industry and many practitioners obviously aspire to, which is a lovely checklist which we can tick off. I think that is a long way off, so and I leave it at that. Thank you.
All I can say is that if the tyranny of choice is a problem for Nestle, God help the SMEs. Right, so let's have all the panel back on stage and we'll answer some questions. Right, who wants to go first? Stunned silence. Come on, someone's got to be first.
We all thought you were asking the question.
All right.
Well, I'm going to have a go in.
Right, Robin.
Well, do I need to speak on that mic? Well, David said, Court of Appeal have never upheld and found infringed a registered design.
Registered community design.
It's community design, all right. And he says there are very good reasons why it should be changed. One, because they give wider rights in Europe. that proposition is not necessarily true. If you remember, in the first of those, Reckitt, we decided to follow the Austrian court, which its description, and which refused an injunction. So that reason ain't so good. Through the French court,
It was upheld in France, Germany, Netherlands, Italy.
What?
It was upheld in France, Germany, the Netherlands, Italy, Spain.
Not for the case. And I don't know why they did, because we had evidence, which they never done. The plaintiffs produced evidence of how everybody praised their wonderful design for this laboratory spray. Henry Clark cross-examined them. So what about this one? Oh, this is rubbish, said the expert. Same impression on the informed user? You only have to look at the thing. I can tell you, I tried these in my classes. Nobody of my students thinks we got that one.
Isn't the problem that said the expert?
What?
It's rubbish, said the expert.
Yes, it's rubbish, said the expert. One is beautiful, the other is rubbish.
But that's the point. That's what informed user closely. They are quite an expert.
Well, I mean, the defendant's one was rubbish.
For the judge who said that registered design cases should be heard entirely without expert evidence,
And decided in half a day.
Apple would have been disgraced. They'd have got a complete monopoly in any tablet.
I agree with you on that case.
Well, you should have put it in there saying, oh, it's an example of things going wrong. Chunky, I think every 5-year-old can tell the difference between an elephant and a ladybird. I think we got them all right. And what's more, I think if you've gone wider than that, you're actually going to impede designers. Finally, yes, the Court of Justice, he said the Court of Justice supported it. The Court of Justice says you can compare the registered design with the article. Unless it's not possible. But it's always possible, because unless the registered design is printed on some sort of stone or something, you can always take it to the article. I think they had in mind that the registered design consisted of a physical thing. But they said you could compare them side by side, miles away from trademarks. It's got to be on that side.
I don't think that was a question. Yes, Darren.
I've got a genuine question, and Darren Smith from EIP. David, again, you talked about, I should paraphrase, but basically putting disclaimer practice, whether line or shading or generalised capture tree, putting and making it mandatory, making it harmonised. Actually, that isn't what you said, but
that would work.
Actually, there are different aspects of, there's harmonised practice, but then making sure that it's observed, putting on the statutory putting. I suppose how do you think that might be achieved in practice and implemented, given that it seems that the one thing that the EYPO won't tolerate is the idea that you might file actual words of your own that they then might have to translate?
Yeah, the difficulty with Sir Richard's suggestion is the translation costs. So if you have to translate every description into 23 official languages, the cost completely flows out for the system. I think there are several ways to do it. One is, for example, the Court of Justice has already upheld the meaning of dotted lines in a case about a watch lanyard and said that they are in the EU IPO guidance and therefore should be applied. That's one way to do it. Another way to do it is for member states through their courts to say, we're going to follow these guidelines. This is what they mean. This is the basis on which people filed the designs with the EU IPO to follow the guidance. So we'll accept it. Another way to do it is through the convergence projects. So the EU IPO, together with the member states and a number of other offices, runs a series of convergent projects to try and bring practice together. That would be another way to do it. Or, as you say, it can be legislated. That's a pretty blunt tool, that last one. But I think there are other ways to do it.
I would perhaps just add to that. I think if you read the Supreme Court in Trunky, it's quite clear from that they say the way you interpret the images in registered design is in their context, and that context includes the principal regulation, the implementing regulation, and the guidelines issued by EU IPO. The problem in the Trunky case was that it was filed before any such guidelines existed. So, or I should say one of the problems in the Trunky case. So there weren't any such things to apply in that case. But I think hopefully, at least in the UK, that will be understood. Something I have thought for a while is that tick boxes would cover many of the common options. If you could tick a box that said shape only or colour included, as you used to be able to do on the trademark form, there was a tick box for colour as part of the trademark. Really, all the little standard forms we used to have, like shape and configuration or pattern and ornament, that kind of thing, you could do that with a tick box and that wouldn't need the translation. In the same way that they have a tick box for ornamentation on the EU IPO form now. So that could be done at form design, I think, and that would probably take out 70-80% of the issues.
Right, another question. Yes.
I think one thing to Martin's talk and the fact that one of the escape routes from the trademark tragedy is relying on acquired distinctiveness. And I think you touched on how difficult it is to provide evidence of acquired distinctiveness of a shape alone when your shape, when your product is actually sold with other marks on it. And it seems to me that one of the key bits of evidence you would think about there is survey evidence. But I think one of the real huge difficulties that people who are trying to get registered European trademark protection is the requirement to provide or show acquired distinctiveness throughout the EU. And it's really, really not clear what you have to do, how many countries you need to have surveys in, how much can you extrapolate.
All of them.
And I was just wondering what your thoughts are on that.
Yeah, well, I mean, if you follow the old Benelux decision in Europolis, you could say, okay, you have to show distinctive character in each and every EU member state, but that's not what I see as a current development. I think the current development is rather that you show acquired distinctiveness in a substantial part of the EU territory. At least this is what you see in more recent case law. So I wouldn't be too afraid about this one, but I have more concerns about the move to survey evidence. I think in practice you see very often that, well, if one party comes with a survey, then the other party comes with a survey, so finally you end up giving the judge so many options just to rely on whatever has been said in one of those surveys that the added value is quite limited. And I think with survey evidence you also have the problem that the deeper your pockets, the more surveys you can potentially afford. And so this also adds a factor to the equation that is not completely fair, I would say. And yeah, with regard to EU trademarks, on the other hand, I mean, if you want this right for the entire EU territory, then I think it's quite logical that you have to show a bit more than just acquire distinctiveness in your home market, and you have to convince the office and the judges that this is something that really concerns the entire territory or potential part of it and not just one individual country.
This issue is, of course, now pending before the Court of Justice in the KitKat case, because, as many people in the room will know, there were two parallel cases. There's the UK trademark case, which has finished in our Court of Appeal, at least to the best of my knowledge and belief. And then there's the EU trademark case, which is going on in parallel. The General Court refused registration on the grounds that it hadn't been shown that the mark was distinctive throughout the EU, but they accepted that it had been shown to be distinctive in some countries, including the UK. And so the principal issue before the Court of Justice is, was the General Court correct to say you couldn't register when quite a lot of major territories it had been held that distinctiveness had been shown. So I think watch this space on that one. Another question? Yes.
Do you feel, or does the panel collectively fear for the validity of all the three-dimensional car registrations that seem to exist? Because they were almost the typical 3D registration from many decades back, apart from the Coke model. I think the car ones are the next ones. Are they all invalid now?
Martin, why don't you have a stab at that?
Well, I'm not so critical about those because I think these could be examples falling in between the two poles. Depends a bit on what type of car it is, but if the design is, depends on how you see the design differences. I think in the car industry, sometimes you have rather incremental steps and evolutions of design and not so much new pioneering things. And so in those cases, I would not be too worried that you really have a shape that is outside the norm or customs in the sector, and I would also not be too afraid about aesthetic functionality considerations. But yeah, of course, a certain percentage of those could have some trouble under the circumstances that have now arisen. But I think it's not an area where you can have bright line rules and saying, well, forget about all of those, or all of those would be valid.
If you follow the reasoning of the Court of Appeal in the London taxi case, then the conclusion would seem to be that a lot of those marks are lacking in distinctive character. The more exceptional cases, the Porsches and so on, they're going to run into the B&O problem of aesthetic functionality. And so the question, as Martin says, is, well, is there some space in the middle?
But I wonder whether, and this is an issue that sort of during the progress of the Houghton Stocker cases, EU-IPO decided at Board of Appeal level several cases to do with classic designer furniture, Eames chairs and that kind of thing, and came to the conclusion, looking at the evidence before them, that whilst these things had aesthetic functionality when they were created, they created this enormous wow factor, you know, this very stark functional furniture made out of modern industrial materials, which had gone into exhibitions, had gone into museums and so on. We'd all sort of got used to it now, actually, and it was just what furniture looked like now. And so, whilst it had started off as being aesthetically functional, things had washed through, and taste does change, I think, over decades, and it may well be that we're, you know, and the same with Porsches, you know, which I never much fancy myself, but you know, we may have got used to what these things look like. It may now be functioning as a trademark because we've got used to it. I'm sort of reminded of what was said about technicality in the context of patent law back in an old case, an oldest case, wasn't it? But where, you know, there was some discussion about the typewriter being technical when it was invented, and the computer being technical when it's invented, and now, of course, we regard those things like a pencil and paper.
But you see, the interesting thing about that is it's the exact opposite argument to the one that was run in the Dualit toaster case, where the argument was, at the time that the Dualit toaster was launched, it was just an industrial product, and only years after the event was it recognised as being a design classic, and surely you can't hold that against them.
Yeah, but I think there's a more general question here. I mean, in the EU law, the aesthetic functionality is a categorical exclusion. And so when the office or the judge takes a decision on this, this is basically a final decision. And it has been questioned in several comments on this, that perhaps aesthetic functionality is something that should be revisited from time to time because, well, consumer perception changes, aesthetic norms change. So perhaps this is something to look into in more detail.
I mean, I have a problem with the whole Henkel doctrine as a doctrine of law. It's finding a fact. It's an assumption of fact disguised as a doctrine of law. You know, that consumers do not normally treat things as things. That is an issue of fact. It's not something we should say, well, it's been decided as a point of law. You know, the Court of Justice is there to decide points of law, not to tell us what people think when they buy things. We don't need the Court of Justice to tell us what we think when we buy things.
But if you treat it as a question of fact, then you need some evidence. And where do you get evidence from that is reliable and cost effective to obtain as to what consumers think?
Well, on that point, you see, the Court of Justice, or the General Court certainly in Nestle, said, well, actually we think certain evidence is good enough, whereas the English court doesn't seem to agree with them. There's a disparity in their views, isn't there, on what is acceptable evidence, which is unfortunate for those trying to secure and obtain rights like that.
Well, but the real difference was that the General Court seemed to accept that mere association was enough, whereas the Court of Justice, on the reference from me, said quite clearly that it wasn't enough. So, I mean, that's more a question of the legal test to be applied rather than the evidence.
Yes, I mean, association is a question you can answer. When you go beyond that, you're asking a question that's very difficult to answer. And if the starting assumption is always that the public do not treat these things as trademarks, then every time the owner of the rights is faced with an impossible hill to climb. You know, starting with a loaded assumption that this thing, you know, here's an assumption of fact, not a proven fact, but the court's assumption that these are not trademarks, which is clearly not, in my view, what was intended when the regulation was drafted, when 3D marks were put into it. You know, it's a hill that is it's a difficult hill to climb, as you say, to find evidence that a mark is functioning, the shape is functioning as a mark, not merely associated with the origin of goods. Maybe it's unanswerable.
Is an answer a tort of unfair competition? So something a bit stronger than passing off, something that doesn't require consumers to be misled or for there to be a misrepresentation. Perhaps a leg up form of unfair competition might be, so, as we have for famous marks, marks with reputation.
Well, that leads on to a more general question, which is, should we have a harmonised EU law of unfair competition rather than the patchwork quilt of national laws that we have presently?
Well, if we want a single market, then the answer to that must be yes.
Yeah. But I think that the answer also should be yes from a systematic point of view. I mean, we see the specific areas of intellectual property absorbing more and more of design and creative works and so on and so forth, because there is no fallback position. And you see that this changes in particular the situation in countries that had this strong fallback position. So in Germany, for example, you have a fully developed legislation on unfair competition, and this was used successfully in cases where judges just felt uneasy about abiding an IP right as such. And I think these statutes do quite a good job within the IP arena, because every time you abide an IP right, you take quite a strong position because you avoid this subjective right to exclude anybody else, whereas competition law is much better for the shades of grey, not only on Valentine's Day.
One last question. James.
I just want to ask David Musker whether you really think there's any practical chance of having agreement across Europe in relation to spare parts. Is there common ground in the debate?
Well, I wonder whether a must-match limitation might do that. The German government and the Commission both argued in the Acacia case that is how the regulation should be interpreted. It might or might not fly with the French, but as I mentioned, from a different corner of the French government, their competition authority has recommended liberalisation of their market. So that was my thought, was that must-match might be a ground that might get somewhere. I mean, we've seen what happened when and people always say, don't ask the Court of Justice a question you might not like the answer, and the answer in this case is clear, as so often, clear on the subject matter of what's covered by the exception. But when you look at what the obligations they've put on the third-party manufacturers, they've made them liable for everybody downstream of them, and it may be that is not really a victory for the third-party manufacturers, actually. So I'm not perhaps overly optimistic, but I think it has to be tried.
I'm wondering, David, if in the absence of agreement, whether we just need a new approach, which is to say spare parts are like any other design, they're protectable, doesn't matter whether they're visible or not, so just remove that entire chunk of the regulation, and say if there are economic arguments for having free spare parts markets, let the antitrust lawyers deal with it. So it's no longer a question of design law, but if they are using those designs to corner markets and drive prices up, let some other...
That's asking for British Leyland and Armstrong to be repeated Europe-wide.
I mean, the reason, in a way, why we had British Leyland was because the MMC published a long hand-reading report about Ford.
Yes.
British Leyland were the good guys who licensed their designs, and Ford were the bad guys who didn't. And the MMC said, well, it's terribly uncompetitive, we can't do anything about it, we can't do anything about it. And they didn't do anything about it. So we got a bad case, and then we got a bad law, and here we are. So I'm not convinced. I mean, I suppose here's us thinking, well, the competition lawyers couldn't do anything worse than we can, but I fear that they probably can.
Leave nothing to competition.
But I mean, I think the cloud on the horizon is, and it's something we say in the legal review, that with the rollback of copyright following the Floss case, and as you say, already everything's protected in the Netherlands by copyright. Spare parts of cars are perfectly aesthetic products, actually, and there ain't no repair clause in copyright law. So, we may be...
So in other words, we could abolish all of registered designs because they'll all be redundant in due course, because it'll all be covered by copyright for life of the author plus 70.
Pretty much.
One thing I would add on the review, if I might, is what is really important, I think, is to ensure that it doesn't all founder on the rock of spare parts. So if we can't reach agreement on spare parts, park it for another 20 years, and at least get through some of the reforms that everybody wants to happen and that need to happen.
Yeah,
right.
I think that's right.
Very good. At that point, I think it's time for drinks. They're in the North Cloister. Please thank all of our speakers.